1 of Seyfarth's Commercial Litigation Outlook webinar series, Insights and Predictions for Litigation Trends in 2022. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Rebecca Woods. Rebecca, you may begin.
Thank you, Sadie. Hello, everybody, and welcome. My name is Rebecca Woods, and I am chair of the Atlanta Litigation Practice Group, and I am co-chair of the National Commercial Litigation Practice Group. We've got a packed agenda here for you. This is the first in a two-part series on our commercial litigation outlook, insights and predictions for litigation trends in 2022. We started this outlook in 2021, and it was so well received by clients that, well, we're making it an annual adventure for everyone. The real value in litigation is assessing what's coming up ahead. Usually we're backwards looking, but today I've pulled together some subject matter experts, and they are going to connect the dots and provide you some thoughtful guidance about what you can expect in the year to come. Now we're running a tight ship here, so each speaker will get only about 7 minutes. If you have questions, I do encourage you to put them in the Q&A, and I will keep an eye on them and pose them to the appropriate human being. So let's jump in for the first speaker. We're going to speak with Bill Hanlon. He is the national chair of the bankruptcy practice. He's based out of Boston, and he's going to talk with us about bankruptcy trends. Bill? Bill, are you on mute?
Can you hear me now?
We can. Perfect.
All right. May I have the next slide there? I want to talk to you about bankruptcy and bankruptcy trends. For a long time, from 2014 to 2019, we saw about 5,500 commercial bankruptcies per year. Business bankruptcies. Why do businesses file? They need the automatic stay. They need to stop litigation. They need to reorganize. They need the breathing room. And then COVID hit 2020. We got a bump up in commercial bankruptcies. In 2021, we got a dramatic decrease in bankruptcies. You might say to yourself, with COVID, why are we getting a decrease in bankruptcies? Well, it's because the federal government made a lot of stimulus funding available, PPP loans, the courts were closed, there were loan, eviction, and foreclosure moratoria and uncertainty. People didn't know how long it was going to last, how long it was going to, how long economic conditions were going to be poor, how long, were they going to return, and courts were reluctant to do anything. If you could get the equivalent of the automatic stay in bankruptcy by going in and saying, COVID, Your Honor. And the court would typically, if it was open at all, say, what do you need, 6 months, 8 months, 12 months? So nobody really needed to file in 2021. That's going to change in 2022. We've got the end of stimulus. We've got courts reopening. We have supply chain pressures. We have rising inflation. We have interest rates clicking up. And what that's going to do is it's going to fill a pipeline. And it's going to fill a pipeline during 2022, which is going to come to fruition, if you will, in 23. Companies that are in distress typically do not go to bankruptcy court as their first resort. What they do is they fight for a while, and they wait until judgments enter, and they wait until loans go bad, and they try and work things out. And then, once they have fought enough and they can't fight anymore, they resort to bankruptcy. Who's going to file in 23? Well, the industries that have been most affected by bankruptcy, by COVID are business-based industries. Domestic airlines have seen a reduction in business travelers. That's who they depend on. They may need some restructuring. Commercial real estate is seeing behavioral changes in office space and in restaurant space, and they may have to respond with restructuring. And healthcare is seeing a tremendous amount of stress. Burnout, increased wages, decreased reimbursement rates. So those, I would say, are the top three industries likely to stagger into bankruptcies in 2023. And we're going to see, I think, a more robust post-confirmation litigation in bankruptcies. We're going to see very aggressive pursuit of preferences and fraudulent conveyances and the typical sort of post-bankruptcy litigation, due in part to the rise of litigation funding. That concludes my prepared remarks for today, and thank you all for joining us, and I look forward to rising interest rates and an increase in business failures in 2023. Take care.
Not that we're too eager for any of that to happen, right, Bill? Okay, our next speaker, thank you, Bill. Our next speaker is Scott Carlson. He is the National Chair for our Privacy and Cybersecurity practice. He's based out of Chicago, and he is going to talk with us about cybersecurity coming up. Scott?
Thanks, Rebecca. So I want to talk about three topics. One of them is ransomware. Ransomware has actually been, it was a bit on the decline at the end of 2021. There's still a tremendous amount of ransomware, but it actually had, its acceleration had slowed and has continued to be a bit down in 2022. Some of this is tied, actually, to the Russia-Ukraine war. Many of the threat actors who would engage in ransomware targets in the United States were largely Russian, Ukrainian, and other East European countries, with Russia and Ukraine probably the strongest. Before the war started, frankly, there was a couple things that happened. The Ukrainian government had rounded up about 10,000 threat actors and had arrested them, and that put a lot of people quiet for a while. And the Russian and the Ukrainian hackers have been busy attacking each other. So essentially there's a certain limited number of resources that can engage in these attacks, and they just spent less time focused on the United States. So what we do expect to happen, though, as the Russian-Ukraine war stabilizes somewhat in the coming weeks and months, we expect that activity and perhaps the increased pressure of sanctions, that Russian threat actors particularly will become more interested in attacking U.S. companies more as a patriotic measure and in support of Russia. So that's what we're expecting to see. I think we'll see a ramp up here in the next couple of months, and we can expect it to return to its original levels and higher. Ransomware has evolved. Originally, we started in sort of an encryption-only philosophy where they simply encrypted your software until you paid a ransom to get the keys back. That moved to encryption and exfiltration, where they threatened to expose your data publicly. These numbers are always a bit anecdotal, but the estimates are that about 80% of ransomware today involves exfiltration of data. So that means they're stealing data that may then lead you into data breach notification issues and other state and federal regulatory issues. The other thing that has happened is ransomware as a service has become more popular. You've all heard of software as a service. Now some of the threat actors are offering up ransomware as a service. So if you and I decide we would like to get in the ransomware business, we can simply rent and pay a license fee to somebody who provides us ransomware as a service software, and we can get into the big game. So that's changing some of the ability for less sophisticated threat actors to enter this business, and it has been a lucrative business. Next slide, please. Which leads to what we have seen, which is a tremendous increase in cyber insurance rates. I've talked to clients, many who have seen double their premiums this year. Some who have seen 5 times their premium increase. Underwriting has become much more difficult. If you want to think of it sort of if you were buying term and life insurance, at a certain age, you probably just fill out a form, or for a certain amount of insurance, you fill out a form, you tell them how old you are, and you tell them whether you smoke or not. And you could pretty much get underwritten based on that. Bigger amounts, you had to take a physical and have blood work done and everything else. Well, that's where underwriting is now for cyber. They're coming in, they are asking you detailed questions about your cybersecurity program. They want to focus on these 10 controls particularly. Do you have multi-factor? Are you doing endpoint detection response? Do you secure your backups? Do you handle privileged access management well? What's your patch management philosophy and approach? What's your incident response training and planning? Are you running tabletop exercises? Do you have a good incident response plan? Are you training your employees? What sort of hardening techniques do you have for remote desktop, other things? What's your logging like? End of life systems being replaced, and then vendor risk management. How are you dealing with the vendors that service you, and also supply chain that ends up putting software into your business? So all those are real issues. In general, companies are finding it extraordinarily difficult to renew, and very seldomly can you increase your the amount of coverage you have. And we're a long way from the days where some people said, I'm just going to handle cyber risk by insuring it. You've got to have a program or you're not going to get insurance. So definitely you have to move ahead. And I would suggest anyone who's underwriting this year, you need to start thinking about that 6 months ahead of time, or 3 months ahead of time, because you're going to get run through a much more closer examination this year than you ever have in the past. Next slide, please. The last thing, sort of trends for 2022, is we are definitely seeing, there will always threaten different governmental regulation on cybersecurity. There was finally the Cyber Incident Reporting for Critical Infrastructure Act was passed. This is going to require, much like in GDPR, where you notify, in the EU, you notify within 72 hours of a cyber incident. This will now impose that on companies involved in the infrastructure. Now, who that is yet to be seen. CISA, the Cybersecurity Infrastructure Security Agency, has, I believe it's a year to write the regs. And generally, they're describing financial institutions and other things, typically the mainstream defense contractors and the folks in the power companies and the people you would expect part of infrastructure, but also your financial systems and financial companies and other. They're taking a very broad sweep as what is critical infrastructure in the United States. So we'll see what the rules come out with, but I'm expecting that will hit a pretty large swath. Healthcare was one that was generally viewed as part of the infrastructure. So not what you would traditionally think of as true infrastructure, roads and power, things like that. The SEC has proposed a rule on cybersecurity risk management. Used to be, if you're a publicly traded company, under the current rules, there was some guidance, but you basically, you had to report material incidents, things that actually affected your ability to report on financials. The proposed rule has defined materiality at a very, very low standard. So things that I know happen to companies on a daily basis, if the rules go through as proposed, I don't think they will, but if they did, it would be a very low bar, and we'll see 8K filings constantly by companies because it's a very low standard. So watch out for that. We'll see how fast. Typically, regs take about 450, 460 days to become real rules. We'll see how excited the SEC is. There's a 60-day public comment period going on right now, and then we'll see where we go. And then finally, they are identifying board experience in cyber is now expected to be disclosed. Not a requirement, but certainly heightening the importance of board involvement in cybersecurity. And that's all I have.
Thank you, Scott. I have to say the cyber hacking and the like scares the dickens out of me. And if on any given day, a company is only as safe and protected as its most feeble, gullible, or distracted employee, and if insurance is going away or becoming unaffordable for many small companies, what is being done? And I know this is a little unfair of a question because it's asking you what's going to happen beyond 2022, but you talked about the disclosures coming up, but disclosure doesn't prevent this storm that's gathering. So any thoughts on how companies can really prepare themselves, and what, if anything, is the federal government doing?
Well, the federal government is limited somewhat on what they can do. They have hacked back at some of the ransomware groups they've publicly admitted this year, and that did put a little bit of a dent in ransomware. But the bottom line is companies have to invest in their cybersecurity programs. People traditionally haven't. They've just said, oh, IT will take care of that. You really need to take a much more proactive stance. I've seen a lot of general counsels now we're running red teams where we're actually attacking the company to let's see where you stand. Because it's one thing to turn and say to the IT people, are we okay? And they go, oh, yeah, sure, we're fine. And then it's another thing to actually test it and attack. So that's what we're seeing. But money's got to be spent, unfortunately.
Yeah, well, seems the online world has made more money and now costs more at the same time. So thank you, Scott. Moving on to Jay Carl, who is our National Deputy Chair for e-discovery. He is going to talk with us about what's coming up in e-discovery litigation. Jay?
Thank you, Rebecca. Next slide, please. So today I just want to talk to you briefly about some trends that we're seeing in electronic discovery. And really this is a trend that we've been monitoring in the way that organizations and companies communicate and store and utilize their information, right? So, everyone I'm sure is familiar with one or more collaboration platforms. And really this is Microsoft Teams, Slack, Confluence, for example, WebEx, Zoom, Salesforce to some extent, and many, many others. And in fact, some organizations have created their own collaboration platforms. So we've seen this trend increase even before the pandemic, but the use of these tools really took off during the use of the pandemic and have continued their upward trend in terms of their use, and are poised really to surpass the use of email for internal and external business communications in many respects. And I'm certain that some organizations already communicate most frequently important information, business information, at least internally, through these collaboration platforms. Now, the quick adoption of these types of platforms have really changed the way that information is stored, right? And in litigation, the typical kind of discovery that we go after in electronic discovery that we see, being collected, searched, reviewed, and produced is more often than not email communications, right? And so, and it's almost as if it's an afterthought to think about these collaboration platforms and the chat communications that are going back and forth in those platforms and the documents that are shared in those platforms. And so we've been monitoring an uptick in motions to compel this type of data. Now, there are many, many different things to consider with respect to this data in terms of, how long it is stored, how we can actually search and collect the information in a useful way. Next slide, please. So just to kind of go over some of the challenges, some of the terms that you'll hear, for example, are modern attachments. What's a modern attachment? Basically, a modern attachment is just a fancy name for an attachment that is linked to some kind of communication. So within these collaboration platforms, within chat, for example, oftentimes if you want to share a document, you'll share a document and that document shows up as a link in that communication. You can also see modern attachments or links within email communications as well, but oftentimes you'll see them in chat communications within these collaboration platforms. And basically what that is that attachment or that key document, whatever it is, isn't directly connected to or embedded in that underlying communication. In fact, the document is stored somewhere else in some other repository. And the challenge is with these tools and platforms, and that is in the haste to implement them, organizations haven't necessarily thought about whether or not they can collect that communication and the attachment at the same time, which causes significant challenges in discovery. Oftentimes the tools themselves do not provide an easy way to collect that information so that they're connected together, both the communication and the attachment with these modern attachments, in a way that makes cohesive sense, right? So these are presenting a lot of challenges. Another challenge that we're monitoring is, for example, the use of emojis. These communications in collaboration platforms oftentimes tend to be a little bit less formal, right, than email communications, right? So, you know, a lot of key information can be in these chats, and sometimes relevant information can be communicated not verbally, or in words rather, but, you know, sometimes in emojis, those things count. The difficulty is, however, in that many of these collaboration platforms don't in fact allow for the export of emojis within the information that is spit out of the tool, right? So you might see an emoji in your chat communications when you look at it, but when you go to search that information, how do you search for emojis, for example? If you go to export that information, oftentimes the platforms will not allow you to export that emoji. You might get, you know, an ASCII reference number as opposed to the actual graphic itself, for example. Another issue to think about, and that often becomes challenging, are threaded communications. So if you think about chat communications within these collaboration platforms, there's really no, oftentimes there's no clear start and there's no clear end to the communication, right? So it is just one very long thread, for example. So if you chat frequently with many of your colleagues, oftentimes it's just a running thread of information and you kind of jump back into the thread. And there might be a start and stop in terms of certain timestamps and certain days, but that does present a challenge with respect to search and export of the information, right? Because you might, oftentimes it's not necessarily a communication that is kind of discrete and logical in that it contains a specific idea, right? Like an email, you might have a thread that kind of goes back and forth and it's all one contained document. Whereas with a chat thread, it may jump from subject matter to concept, and no clear delineation of a specific thread about a specific concept or an idea or subject that has like a, you know, a subject line like an email does. So oftentimes we'll export that information in like 24-hour increments, but there's many, many different ways to do it. And again, oftentimes these tools don't necessarily have built into them the capability to, you know, export in specific chunks of temporal scope, for example. What is a channel? Another issue is a channel, and a channel is becoming across platforms broadly used for the concept of having multiple people involved in a collaboration environment or a collaboration team or a chat. And so you might have one or more people within a channel. You might have, and then you might have breakouts. You might have people chatting specifically with each other in a chat, a private chat, and then you might have teams or channels, which are groups of people. And the challenge there is that even if you identify one specific person who should be subject to preservation requirements and a legal hold, and you place that person on hold, it may not, in most cases, it's not going to preserve all the relevant information that might be in that channel just because you placed one person on hold. And conversely, there's an issue that if you place a channel on hold or a whole team, oftentimes you're preserving information more broadly than you need to, right? If there's 100 people in the team or 100 people in the channel and you only need to preserve for a few, sometimes you just need to preserve the whole lot in order to effectuate preservation of the few. Another issue is preservation and search. Oftentimes these tools, depending on the licensing level for many of them, and of course it's more expensive to get all the e-discovery bells and whistles, but many tools don't natively have the capability to effectively search within the tool to export. So, you know, what is the lesson in all this? You know, ultimately the lesson is, you know, it's important to think about collaboration tools up front when, you know, preparing for litigation early on in the preservation stage, and then also planning your discovery strategy in terms of identifying information that you'll need to produce for it. You know, in thinking about even in the outside of the current litigation, planning for it into the future and looking at the native tool set, figuring out how you're going to execute in the preservation and export of that information, looking at third-party tools and third-party partners who can help you, you know, preserve, search, export, and deal with the collaboration platform information. And then finally, you know, it can be very costly to conduct e-discovery on this type of data. And so it is important beforehand to think about your proportionality arguments to the extent that you think that you may be on the hook for conducting discovery on a large volume of collaboration information. Thank you very much.
Thank you, Jay. I know as a commercial litigator, happening upon the very terrible email that the other side wrote is something that's increasingly less occurring because more people are treating email as more formal, whereas these collaboration platforms sound rife for lots of casual speak that can get people in trouble later on. So fascinating. Good. All right, let's move on to the Fair Credit Reporting Act and my colleague here in Atlanta, Esther McDonald. She is a partner in the Commercial Litigation Practice Group, and she's going to talk with us about the FCRA. Esther?
Thanks, Rebecca. Let's jump right in and start with increased regulatory oversight. Under the Trump administration, we had seen the CFPB and the FTC kind of back off a bit, but with President Biden's election, these agencies have signaled their intent to engage in robust supervision and enforcement, and they've come out early in the administration and kind of outlined their priorities for us, which is helpful. They are focused on imposing equity, so they're looking at how companies' practices affect minorities. And they're also looking at obtaining monetary relief. They're exploring new ways to obtain that. The Supreme Court limited the FTC's ability to get monetary relief in AMG capital management. And so both agencies are pursuing new avenues there, trying to find opportunities to get monetary relief back to consumers. And then they're also looking for opportunities to expand their authority. As we know, it had been kind of restricted a bit under the Trump administration, and so we're seeing, we're moving into an era of kind of broader authority now. So practically, what does this mean for businesses? Well, when we talk about consumer reporting agencies, which would be credit bureaus and background screening companies, as well as data furnishers, companies that provide data to these entities, the bureaus, the agencies are looking at accuracy. This is a long-standing interest of the agencies, but we're seeing an increased focus on how accuracy impacts minorities. And so the CFPB has come out with some reports that talked about how the risk of mismatching may fall heaviest on minorities, particularly because there is less surname diversity among these populations. So the CFPB, we expect, will be looking at matching procedures and whether there are sufficient identifiers that are considered by credit bureaus and background screening companies. They're also looking at consumer disputes. The CFPB released a report recently that found that Blacks and Hispanics were more likely to have disputes on their credit reports of inaccurate information. And inaccurate information can lead to an inability to obtain credit. So the CFPB is looking at that to ensure that credit is widely available to minorities. So companies want to be assessing their data and their policies internally and looking at, you know, what are you doing to ensure accuracy? Often companies that collect this data are not categorizing the individuals, the consumers, by race. So there can be some difficulty there. But you want to make sure that you're doing what you can to ensure that you have procedures and policies in place to make sure things are accurate. You should always be revisiting your policies. And then disputes are always, we say, put your best people on disputes, because that's where litigation and investigations arise. So another area we're seeing the CFPB and FTC look at is with data brokers and big tech. And so for a long time, entities kind of brokered data outside of the FCRA, and the CFPB and the FTC are looking a little more closely at that. And that comes from an increased view of privacy in the United States. And so what are you doing with the data? Does the FCRA apply to you? So recently there was some litigation where a data broker argued that it was not subject 2 liability because it had immunity under Section 230, and we saw the CFPB and the FTC have filed an amicus brief in that case arguing against that. Next slide, please. And then, so what are we seeing in the litigation front? Well, this takes us back a bit to accuracy matching. We're seeing increased litigation on matching. That continues to be a problem here, and the industry and the consumers and the agencies are expecting better matching procedures as we go forward. Particularly on name-only matching, the CFPB issued some guidance recently that said name-only matching violates the FCRA. Interestingly enough, this came on the heels of an 11th Circuit decision from 2020, Erickson, which held that background screening companies' name matching procedures that matched based on name only, first and last name, were sufficient under the FCRA. So the CFPB in its legal guidance did not address how its guidance was consistent with the 11th Circuit's opinion holding that this was lawful. So that's something to be aware of. Any companies that are doing name matching only should just be cognizant of that. The CFPB will be looking closely at that. And so to that end, if you're going to be doing that, you want to make sure you have adequate explanations and qualifiers just to make sure that you are adding clarity to your reports and they're not misleading. And then another area where we're seeing litigation is on common names. There's no industry standard for what is a common name, but we're seeing credit bureaus and background screening companies look at the SSA's lists as well as their own internal data and then geographic subsets. We know that certain surnames are more common in certain geographic areas of the country. On credit reporting, we're seeing increased litigation with the CARES Act. The CARES Act said that if an accommodation was made to a consumer, that the report, data furnishers needed to report the account as current, or if it was delinquent at the time of the accommodation, maintain that status. And so we're seeing increased litigation over that. So what companies need to do here is just make sure you're documenting your accommodations and make sure that they're being properly reported. We're also seeing an increase in bankruptcies again, and we expect consumer bankruptcies to rise, and then legal disputes. Last, on liabilities and damages, we had a good decision from the Supreme Court in Ramirez, and in that case, the court confirmed that all class members must have standing at final judgment, and standing requires concrete harm, which may be lacking if inaccurate information is not disseminated to third parties. So this is good for companies, and we're seeing more pushback here. More cases and class actions are going to see challenges based on standing. Then also on willfulness, this is the real risk under the FCRA to companies because there's punitive damages here. We're seeing a consensus arise among the appellate courts that if a company's conduct comported with an objectively reasonable interpretation of the statute, the defendant cannot be held liable for a willful violation. So this is a good movement. The plaintiff's bar continues to argue that, no, you have to show that you actually adopted that interpretation, but the circuit courts are steadily holding, no, it doesn't matter what you did subjectively as long as you can objectively show that your conduct comported with a reasonable interpretation. So that's where we're seeing litigation, and companies just need to continue to review their policies and procedures, and I'm going to throw it back to Rebecca to pass on to our next topic.
Well, we're not done with you, Esther. You know, I've only barely touched the FCRA, and while I'm sure I know there was good intent and good work that the statute does in terms of protecting some people, we also know that it's poorly written, and the plaintiff's bar has taken significant advantage of hyper-technical arguments that have gained some traction, and part of what you described was, I think, some of the court's pushback. So I suppose the question for you is there any movement or hope that Congress will tinker with the statute to make it more clear and align with the original intent?
Well, there's always a push in Congress but lately the push in Congress has been to expand the FCRA, which is not good for business. I don't think that there's just the consensus there. The consumers right now have the upper hand in the plaintiffs' bar in Congress. So I don't think we're going to see much push to clarify things for businesses. And there was a push to get the agencies to put out some, particularly the CFPB, to put out some regulations and some guidance that would clarify things. And so I think we're going to continue to see some push there, but I don't know if in this administration that business will get the clarity it's looking for.
Okay, thank you for that. All right, now we're going to move on to franchise and distribution. John Skelton is a colleague of ours in the Boston office, and he is the national chair of the Franchise and Distribution Practice Group. John?
Thank you, Rebecca. Next slide. The last several years, we've had a lot of change just in the business environment generally. We've gotten, obviously COVID. Technology has increased. Several of our speakers have talked about the impact of that technology. Gig economies have really come to the forefront. All of that has led to change. And I want to highlight two aspects of that change and how they affect the franchise and distribution world. Number one is that that change has brought about more scrutiny of workers and worker classifications, and we are now seeing that in taking a look at franchise models and how does it apply. And then secondly, I'll talk briefly about how a lot of that change has led franchisors to kind of reevaluate some of their business models and tweak them as necessary. And any kind of change brings about challenges, and so franchisors face those challenges. On the worker classification issue, franchisors, virtually every franchise agreement identifies franchisees as independent contractors. Really, it should be independent businesses, but they say independent contractors. And when you're evaluating whether an individual or an entity that is providing work or services is an independent contractor or an employee, courts apply. More than 30 states have what they call the ABC test for identifying that classification. You can see the elements here: freedom from control, providing services outside the franchisor's usual business, and engage in an independently established trade. Literally applying those to the franchise model makes it challenging, because if there is a classification challenge, the putative employer or the franchisor must prove all three, and if you miss on one, the person is presumed to be an employee. All of that gig economy stuff has intensified that and has brought that focus onto the franchise model. And you see there's a fair amount out in California. And so a quick summary of the legal landscape: California Supreme Court several years ago in a case called Dynamex. It was a delivery case. It wasn't a true franchise case. They adopted the ABC test, and the way they adopted it kind of left it wide open to applying to franchising. They never really addressed that. California legislature immediately adopted what's called AB5, adopting that ABC test. You've had litigation out in California where the cleaning services industry in the Ninth Circuit in the Vasquez case basically said ABC applies to franchising and there's no special exemption for franchising. That has led to the IFA mounting all sorts of challenges to the application of the ABC test to franchising, and their most recent attempt was dismissed. So it kind of sounds a little bit ominous, but most recently the Massachusetts Supreme Judicial Court, next slide, they decided a case March 24 in a 7-Eleven matter, Patel versus 7-Eleven. So Massachusetts has their own version of the ABC test. And while the Massachusetts SJC decided that, yes, the ABC test can apply to the franchise relationship, there is a threshold question whether the worker, the franchisee, is actually providing services to the franchisor. That's important because in a normal franchise, in a true franchise context, franchisors for a fee provide services to a franchisee, not the other way around. It really highlights the need for franchisors to be able to show that their relationship does in fact allow that franchisee to operate an independent business. Most significant risk is in the owner-operator model, and what we're now having to look at is franchisors being able to show that they do establish an independent business relationship. Who's setting the price? Who has the customer relationship? Does the franchisee truly have an ability to grow that business? And, you know, the old saying, follow the money. Who controls the financial transactions with respect to the customers? The more control that the franchisor exerts over that entire relationship, the more it may be seen as simply a providing services and not an independent business relationship. We're also seeing the risk here is not just in the true franchise relationship, licensing, distributorship, joint ventures, other kinds of commercial arrangements all have that risk. Next slide. So the second thing that we're seeing and we're anticipating is that, as I indicated, all this change has brought upon modifications by franchisors. Many have, evolved their business models, less reliance on the traditional brick and mortar, more e-commerce, more app-based business entities. And what that does is it creates new challenges, you know, especially where everything now has to have a home delivery aspect. Well, how do we now define the territory if you have multiple franchisees in a market all delivering to the home, depending upon, you know, who's calling whom? How do you measure and how do you evaluate performance if you're not, you know, looking at how much business is being conducted in the four walls? Obviously, your image standards and your other operating standards always have been important. How do you enforce those in this now e-commerce environment? And then, of course, franchisors obviously have to disclose all this in their FDDs. That also focuses quickly on social media. It's so dominant in today's environment. And how do you harness and manage and how do you harness the power of social media for terms of advertising? But likewise, how do you protect your brand? And the critical thing, and we've been working with a number of our franchise clients, is developing pretty robust social media policies. Rebecca, unless you have questions, I'm good.
John, I'm fascinated by this misfit between the case law that's evolved on independent contractors and non-franchisor business contexts, and then taking that same case law, the ABC test, and then applying it to the franchisor context seems like trying to fit a square peg into a round hole, and relying on case law will create just a patchwork of decisions. Is there any movement either in states on a statutory basis or at the federal level to define the franchise relationship so that it's not being so threatened by this other arguably inapplicable case law?
So on the federal level, most recently, the PRO Act would have actually adopted the ABC test nationwide, which would have been terrible for businesses. You're actually seeing some states try and go further on the ABC test. Like I said, California has led the way. So you're not seeing real clarification there. And so that's why I actually think that the Massachusetts, the Patel decision, where the court identified that threshold question. There's a similar threshold question when you just look at the statutory language out in California, because you have to be a hiring entity, and franchisors shouldn't be hiring entities. The problem is, you know, no court other than the Massachusetts court, no state Supreme Court has really grappled with applying that square peg in a round hole to franchising.
It seems like franchisors are collateral damage for with regard to this case law on independent contractors, like the Uber type situations, Or is there like hostility to the franchise model, the classic, McDonald's type model?
No. As a matter of fact, most of the case, the cases talk about, franchising is, just a colossal industry. The problem is that, what the Massachusetts court said was, we don't want to exempt franchising per se, because we don't want to create an incentive for somebody to try and structure something as a franchise that really isn't a franchise. It's not really an independent relationship. You're just trying to, create a scheme to avoid the wage and hour laws. So again, I think for franchisors, licensors, distributors, you better be able to take a hard look at your relationships and make sure that you can establish that franchisee truly is operating an independent business.
Wow, sounds like quite the thicket. We're glad we have you. Thank you, John. All right, let's move on to privacy. Emily Dorner, an associate in our Chicago office, who's in the Global Privacy and Security Practice Group, is going to walk us through the privacy issues to come. Emily?
Thank you so much, Rebecca. So there's a lot going on in the privacy world right now. I'm going to try to cover some of the high points from 2021 and going into 2022. So to kick things off, the United States now has 4 states that have passed data privacy and protection laws. And there's some common themes that we're going to address across these laws. But first, I wanted to address a question that I'm sure a lot of people have, which is, can we expect a federal privacy law? And that would be outside of protections afforded by HIPAA, GLB, FCRA. So while multiple attempts have been made here, as each state begins to pass their own state-level privacy legislation, we just feel like we're getting further and further away from federal legislation. And this is becoming more and more consistent with state-level breach notification laws, wherein each state has their own laws with regards to compliance with breach notification, breach reporting, and other breach-related obligations. So in terms of state-level privacy laws, what states have taken the lead? Similar to what John just said with regards to California leading the way with the ABC test, we see California leading the way in terms of data privacy law. So we had the CCPA, which is already enacted, but in 2023, we're going to see the CPRA being enacted, which was passed by ballot measure back in November. Since that passage, we've also seen Virginia and Colorado, as well as most recently Utah, passing their own state-level privacy laws. We'll see the Virginia and the Colorado laws going into effect January 1st of 2023, and the Utah law going into effect on December 31st of 2023. So as I mentioned, these laws do have some common themes that we expect to see even as more states begin to enact their own privacy legislation. And the first one I want to talk about is sensitive personal information. So this can be information such as social security number, driver's license number, geolocation data, religious or ethnic background information, or even biometric data. And we're seeing increased protections around this type of information. So the limitation, consumers will have the right to limit the processing of their sensitive personal information. There will be retention limitations, disclosure limitations, and potential consent requirements surrounding that data as well. In addition, Colorado has even included children's information as a category of sensitive personal information. And that kind of segues us nicely into another trend that we're seeing, which is a trend related to the protection and strengthening and protection of children's data. So in addition to Colorado adding children's data as a category of sensitive personal information, we're also seeing California with CPRA tripling the fines for the collection and selling of children's information when a business has actual knowledge of a child's age. And I kind of emphasize actual knowledge because the CPRA has further stated that a willful disregard of a consumer's age is seen as an actual knowledge of their age. In addition, we're also seeing an emergence of the requirement of privacy risk and impact assessments. So this should sound really familiar to companies that are currently dealing with GDPR. But essentially what's happening is in California, Virginia, and Colorado, not in Utah right now, the state privacy laws require an independent and documented risk assessment related to the processing of certain processing activities. So those processing activities, for example, under CPRA would be when there's a significant risk to consumer privacy or security. Again, really similar to what we've seen with GDPR on that front. In addition to the emergence of new state-level privacy laws, we also in 2021 saw some amendments to state-level breach notification laws. So for example, in Connecticut, we saw them broadening their definition of personal information, but then shortening the timeline for notification regarding the breach, and an additional requirement to provide credit monitoring when a Social Security number is breached. In addition, we saw Texas make some subtle changes to the information that's required to be reported to the Texas Attorney General in the event of a notifiable breach. This came after some 2019 amendments that actually decreased the amount of time that businesses had to report breaches to consumers, among other things. So in general, we expect more states to kind of follow this trend of looking at their notification timelines, and this would be notification not only to consumers, but to state attorney generals, and maybe tightening those up. Looking at their AG reporting information, AG reporting requirements, and assessing the information that needs to be conveyed to the attorney general. And also potentially imposing some requirements with regards to credit monitoring when certain types of personal information are breached. Scott actually already covered cyber incident reporting requirements, so that would be that 72-hour requirement that he spoke of earlier. So I'll kind of gloss over that and move on to other privacy news. So we just recently in the last month or so, the US and the EU reached an updated data transfer agreement in principle. And this is in the wake of the Schrems II decision in July of 2020 that invalidated Privacy Shield. So we no longer have this EU-US agreement or a safe place to kind of transfer data. It could be a long time before we see any final text on this new EU-US agreement. Max Schrems, who you recognize from the Schrems II decision, has already come out and said, he doesn't really expect this to be much different than what we've seen in the past. So finally, we've got the Department of Labor who issued in 2021, a three-part cybersecurity guidance package for benefit plans that are subject to ERISA. This guidance contains cybersecurity best practices, tips for hiring service providers, and finally, online security tips. Next slide, please. So what can businesses do between now and the end of the year to prepare for all of this? So those organizations that will be subject to the new legislation that we discussed, especially the state privacy level legislation, we would recommend reviewing and potentially modifying internal processes and documentation to address these laws. So an example of that would be the consumer rights that come along with these privacy laws. Organizations are going to need to prepare to receive these types of requests and respond to them. Further, kind of as Scott discussed too, the importance of data security is only growing. So organizations should take time to invest in building programs to maintain compliance with sector-specific laws, but also to do as much as they can to prevent cyber issues in the first place, because we're seeing these changes in cybersecurity laws, and we don't want our clients to have to deal with them if they don't have to. And then finally, with the publishing of new standard contractual clauses in Europe, as well as this new potential US-EU data transfer mechanisms, we'd urge our clients and organizations to evaluate cross-border data transfer activities and update transfer mechanisms appropriately. And that's all I've got on privacy.
All right, thank you, Emily. For the sake of time, we're just going to jump right to Kate, our last speaker. Kate Schumacher is a partner in our New York office, and she's going to tell us about securities litigation. Kate?
Thank you, Rebecca. So in what time we have remaining, I'm just going to very briefly highlight a number of hot topics in securities litigation and enforcement to look out for. First, cybersecurity, which you've heard a lot about already. It's obviously a vital issue for virtually every business. From a securities litigation exposure point of view, the manner in which those risks are disclosed to investors is really the key issue. Existing SEC rules don't explicitly require cybersecurity disclosures, instead leaving management the discretion to reveal information based on standard materiality assessments. But As Scott mentioned earlier on the panel, on March 9th, the SEC proposed rules that would require companies to disclose cyber breaches within 4 days upon determining that an incident was material. If the SEC rule is adopted, we'll likely see an uptick in securities suits relating to cyber disclosures. Plaintiffs' lawyers have already tried this. They've already brought claims in cyber-related securities lawsuits, but they've had limited success to date. But some recent rulings are indicating that the tide may be turning, and plaintiffs' lawyers have, on a couple recent occasions, been able to get past the motion to dismiss phase. So that's something to look out for. Another hot topic is SPACs, special purpose acquisition companies. SPACs have been around for decades, but there was an unprecedented increase in those entities formed in the last 2 years. The SPAC process involves a number of public disclosures, each of which carries some securities litigation risk. Dozens of shareholder class actions have been filed of late, most alleging fraud or 10b-5 claims in connection with disclosures about the acquired company's business or prospects, and other shareholder claims have been brought derivatively against sponsors, challenging the structure of the SPAC and the methods of compensating the sponsor. And then on the enforcement side, on March 30th, the SEC proposed rules which seek to eliminate the safe harbor protections of the securities laws for forward-looking projections with respect to SPACs. And that would create stricter liability with respect to disclosures in the de-SPACing transaction. So if those SEC rules are adopted, we'll likely see actually a significant decline in the use of SPACs as a way to take companies public. For anyone interested in a more deep dive into securities litigation and enforcement issues concerning SPACs, the firm actually has an upcoming webinar devoted entirely to this topic on April 26th. So you should look out for that if that's of interest. Another area, cryptocurrency, sort of known as the Wild West. One of the key issues to watch in 2022 is the potential for clarity on resolving what category cryptocurrency belongs in for purposes of the securities laws, a security or a commodity. If it's a security, it is of course more highly regulated. The SEC chairman announced several initiatives during a speech last week to expand investor protections in the crypto market. And the chairman's comments actually follow about a month after President Biden signed an executive order calling on the government to examine the risks and benefits of cryptocurrencies. So in addition to this heightened regulatory scrutiny, we also expect to see continued increase in the number of breaches and fraud lawsuits involving crypto. So that's another thing we expect to see on the rise. Another hot topic is meme stocks, and that is just a clever term for a stock that gains popularity among investors through social media. And the term was born out of the controversy last year surrounding the popular investing app Robinhood and its decision to freeze the trades of GameStop, citing issues with volatile stock and regulatory requirements. And so in response to those issues and the publicity surrounding that, the SEC has made a number of proposals relating to short selling in the last few months that would expand reporting on short sale positions, and meme stocks could certainly be impacted by that. And where you have increased market volatility, that also leads to increased stockholder litigation. There's been dozens of class action lawsuits filed against Robinhood and others alleging securities violations, and FINRA fined Robinhood millions of dollars. So that's going to be a focus for both regulators and plaintiffs' lawyers. And then the last hot topic is, or trend to watch, is sort of the increased litigation and enforcement risks associated with ESG disclosures. That's environmental, social, and governance. On March 21st, the SEC proposed climate-related disclosure requirements that would require companies to expand the breadth of their climate-related disclosures in all SEC filings. And this raises, as you can imagine, a host of questions about how much to disclose, how much is enough. And this is just another thing for companies to keep on the radar in terms of their disclosures. So those are sort of the hot topics that we're seeing. And look at that, it is exactly time.
Excellent. Thank you so much, Kate. And finally, our code, our CLE code is SS2317. Again, that is SS2317. We thank you all for attending, and thank you for my sage speakers. Everyone have a good day.